Welcome to Go Ratio. We are here to improve our skills in the legal reasoning section of the exam CLAT. The best way to improve our skills in CLAT for legal reasoning is to look at past year question papers and solve questions from them. So, in this series of videos, we will be looking at past year questions from legal reasoning section of CLAT. Today, we are looking at one of the passages from the legal reasoning section, which is about the COVID-19 pandemic. So let us first look at the structure of the questions in CLAT. The structure is that there is a passage. There is a long passage. We have to study that passage. And on the basis of that passage, we have to answer some questions. So the method that we are going to use to solve these questions is to skim the passage quickly and then slowly answer the questions. If we have any doubts as to what the passage contained, we will go back to the passage at the relevant place, check, and then answer the questions. So our aim has to be to skim the passage quickly and to know what information is where. So let's start by reading this passage. This says that this paragraph says that as a result of the pandemic, enforcement of contracts and transactions has become an issue. There have been delays and people are not able to do normal operations. So this is a basic introduction paragraph. This second paragraph says that people can fall into breach of contract, that it is possible that people breach contract. But what if they don't want to breach a contract? Then this paragraph says people can rely on force majeure and material adverse effect clauses. So people can rely on force majeure and MAE clauses. And when will they rely on this? In order to escape breaching a contract. This paragraph talks about what are the kinds of things that are covered by force majeure clauses. It says it covers natural disasters like hurricanes, floods, earthquake, etc. Then it also covers war, terrorism, civil disorder, fire, etc. It says broadly, the courts consider force majeure to be an event that can neither be anticipated nor controlled by either of the parties. So something that is beyond the control of the parties will be considered a force majeure. Now, this paragraph says that MAC is different from force majeure. MAC takes place before the completion of a contract and force majeure takes place during a contract. Now, this paragraph also says that what would be the impact of force majeure clauses? The impact would depend on contractual terms. The impact would vary based on contractual terms. So depending on what contractual terms exist, we will know what force majeure events are and what would be the effect of force majeure clauses. Then what are the ways in which force majeure clause can be expressed? It says it can be expressed by using these words as prevented, hindered, or delayed, right? And depending on how the clause is formed, parties can rely on these clauses. Then this says, what is the impact of force majeure clause? The impact is the contract can be terminated. The impact is the contract can be suspended. The impact can be customized by the parties. So what would be considered force majeure? To be determined by parties in the contract. And what would be the impact of force majeure? Also to be determined by the parties in the contract. So once I've reached this stage in the passage where I've read the complete passage, these two ideas are clear to me. What is in a force majeure clause? To be determined by the parties. What would be the impact of a force majeure clause? To be determined by the parties. And then the third thing that is clear to me is that MAE clause is different from a force majeure clause. So let's look at what is the question. It says, based on the author's argument above, which of the following is correct? First, force majeure clauses generally have a uniform impact on the performance of contracts in all the cases. That's not correct. See, you remember the idea was that force majeure clauses will have varying effect on the performance of contracts. Second says the impact of contracts by the usage of force majeure clause is dependent upon the way such clauses have been constructed. This is correct. Option B is correct, that depending on the way in which force majeure clause has been written, the impact on the performance of the contract will be decided. Let us quickly look at C also, just to make sure that C is also incorrect. Both force majeure and MAC clauses have similar impact on performance of contracts. That's incorrect. Force majeure is during contract. Material adverse change is before completion of contract. Now let's look at, so the answer will be B. Let's look at 68. Imagine there is a domestic commercial contract for supply of certain goods for certain price between A and B. However, in pursuance of the same, both A and B forget to negotiate and agree on the terms of a force majeure event. So here I am thinking that, look, there is no force majeure clause. If there is no force majeure clause, then what will happen? Then the parties will breach the contract. Because if you remember, the passage said that force majeure clause is used to escape breaching a contract. So in my mind, I am already thinking that the contract may be breached, and the contractual document does not contain the force majeure clause. So there is no force majeure clause. Therefore, contract can be breached. In such a situation, what would be the fate of the contract? Now, in my head, I already have the answer. The answer is the contract will be breached. So that I will try to look for that in the answers, on the options. Option A, as the parties did not negotiate on the force majeure clause, either of them cannot take an exception to breach of contract. That is correct. And just to make sure that we are correct, we will go back to the passage. We can, we don't have to. We can go back to the passage. And if we look at this paragraph, we remember that breach of contract was mentioned in paragraph 2. If we look at this paragraph, we will be sure that the answer is correct. We can go back to the passage and look. Option B and option C. Option B is definitely incorrect, because there is, because the facts don't tell us that there is any MAC clause. Now, CLAT, I believe, has made a mistake here. CLAT has said that the answer here is C. CLAT has said the answer here is C. Now, in my humble opinion, CLAT is wrong, because in order to mark C, I need to know from the passage that it is the Indian Contract Act 1872 that will apply. Does the passage mention the Indian Contract Act 1872 anywhere? The answer is no. The passage does not mention Indian Contract Act 1872. And if the passage does not mention this, then I cannot apply external knowledge of the law to the question. I will only apply what is given in the passage, and that would be option A. Let's go to question number 69. In the same fact situation as mentioned above, with the modification that there is a force majeure clause in contract between A and B. So now there is a force majeure clause. Let us suppose that B, who was to supply goods to A on certain date and time, faced issues in relating to procurement of goods due to a mill strike, and also because of rise of prices in goods. So now there is a force majeure clause. We have to figure out, will this force majeure clause allow us to suspend the contract? In this case, can B claim suspension of performance of contract on the basis of force majeure clause? Now, what were the two things that we remembered? We remembered that when the force majeure clause will be triggered can be determined by the parties, and how it will be triggered, what will be the impact of triggering a force majeure clause, that will also be determined by the parties. So depending on how the force majeure clause is worded, for B can claim suspension. If the force majeure clause is worded in a certain way, B can claim suspension. If it is worded in a certain other way, then B cannot claim suspension. So let us look at what the options are. Option A, yes, B can, depending on the way the force majeure clause is worded. Correct. Now here again, I believe, in my humble opinion, CLAT has made a mistake. CLAT has said the answer is B. Now, in real life, one may make an argument that B is correct. That requires knowledge of real law, real external law, which is not mentioned in the passage. Therefore, what will we mark? We will mark what according to the passage is correct, and that, in my humble opinion, is option A. Question 70. Typically, MAA provision in an agreement contemplates events which, if they occur or are likely to occur, would have a materially adverse change or effect on the assets, business, property, liabilities, financial condition, results, operation of the target, or that affects the ability of the transacting parties to consummate the transaction, or the validity or enforceability of the transacting parties to its rights and remedies under the transaction documents. Which of the following clauses resembles an MAE clause? So if something will affect the party's ability to enter into a contract, that would be an MAE clause. What was a force majeure clause? That if some supervening event happens, like a natural disaster or some war or some act of terrorism, those clauses were covered by force majeure clauses. So if some supervening event happens, that is force majeure. If something causes the party to be unable to enter into a contract or changes their ability to enter into a contract, that is a MAE clause. So this question is asking us which of these clauses which are given below, which of these clauses is a MAE clause. So let's look at A. In the event either party is unable to perform its obligations under the terms of this agreement because of act of God, strikes, equipment of transmission. The moment I saw act of God and strikes, what was in my head? In my head, this is a force majeure clause. Why is this a force majeure clause? Because this is considering an event which can happen because of which the contract may have to be terminated or suspended. Right? So if the party is unable to perform its obligations because of act of God, etc., such parties shall not be liable for damages. This is a force majeure clause. Let's look at second. Except with respect to payment obligations under this agreement, no party shall be liable for, nor such party shall be considered in breach of this agreement due to any failure of its to perform its obligations under this agreement as a result of cause beyond its control. The moment I see cause beyond its control, I think force majeure clause. And again, just to clarify this, they've given examples. It says earthquake, labor problem, unavailability of supplies. So what is this? This is a force majeure clause. So A is also a force majeure clause. B is also a force majeure clause. So which option will be correct? D. Because neither of these clauses is a MAE clause. So that was the first passage from CLAT 2020. In the next video, we would look at the second passage from CLAT 2020 in order to improve our skills at legal reasoning. Thank you.